So welcome to the workshop. I'm extremely happy that the workshop could take place, and my apologies again for having had to postpone it. Unfortunately, the new date means that we lost a couple of participants, which couldn't be helped. But I'm especially sorry that Raluca Grusescu could not make it this time. She had to, she had to cancel at the last minute due to an appointment. But I was very inspired by her work and by our conversations, and she might still contribute to the publication. The new date also means that although the panels had a certain thematic coherence in the original planning, or at least I hope so, I kept having to shuffle and reshuffle the participants for various personal reasons, so that now the papers don't necessarily answer to each other within a panel. However, as long as they're interesting, I think it doesn't really matter. It's also a bit sad that it is yet another one of those Zoom conferences or Zoom workshops. But on the other hand, it gave us the possibility to put together speakers from 3 different continents, which would not have been possible otherwise. So it's rather a good thing. Now, I suppose not all of you know each other, so let me explain why you're here and why the others are here. I invited each of you, regardless of your discipline, for the unimpeachable reason that I read your work and I found it extremely interesting. I'm aware that several of you are not exactly in your thematic comfort zone, and to be honest, neither am I. But I'm guided by intellectual curiosity and by the wish to look at things from a wider angle, be it from the chronological, thematical, geographical or disciplinary point of view. And I'm certain we can all learn from one another. And I hope you will agree by the end of this workshop. Now, the primary reason why I wanted to convene this workshop is because, like almost everyone else in Central Europe, I think, I'm extremely dissatisfied about the state of post-communist justice. In most countries, the vast majority of the people who led the communist repression, including its worst aspects, such as torture and deaths, have had very little to fear from post-communist justice. In the Czech Republic, the country from where we convened this workshop, less than 10 people went to jail after 1989 for their participation to the communist repression. So how can the people who rendered possible a dictatorship that lasted for 41 years get away with it so easily? This is all the more unsettling that at the same time, the political narrative from officials and intellectual elites in many of these countries is very anti-communist. So how can the memory politics of a state claim to implement a radical break from the previous regime while at the same time achieving very little when it comes to sentencing the former perpetrators? All the while, we keep hearing 3/4 of a century later about attempts to put to justice perpetrators of the Second World War. So it is apparently possible, when there is sufficient will, to pursue justice for a very long time. So, well, why not start now with communist crimes instead of waiting 70 years? As historians, we know for sure that such crimes or acts of torture were committed, but it is quite another matter to talk about them in a court of law. The purpose of this workshop is both to study the impediments to such post-communist justice in Central Europe and to learn from other cases and other historical experiences. Such impediments were the necessity to preserve the continuity of the state, the expired statutes of limitation for the most serious political crimes committed very often under Stalinism at the beginning of the 50s, and the fact that several of these crimes were not considered crimes under communism, under communist law, for instance, shooting down escapees at the border. Now, transitional justice in the post-89 regimes seems to have ignored, however, a key legal concept, that of crime against humanity. Could international law have helped them to abolish statutes of limitation and bypass the narrow definition of what constituted a crime under the communist dictatorship? That's the question. The notion of crime against humanity was introduced, as we all know, but that was repeated for the first time by the prosecution during the Nuremberg trial in order to convict former Nazi officials. The second step of its establishment in international law was the Convention on the Non-Applicability of Statutory Limitations to War Crimes and Crimes Against Humanity, adopted by the United Nations in 1968. It is relevant to mention it here because the nations of the socialist camp, as opposed to almost all Western countries, ratified it in the 1970s. And the final step was the 1998 Rome Treaty, which consecrated the category of crime against humanity as an international legal tool. Moreover, the European Court of Human Rights stated in 2001 that communist crimes had infringed human rights and their prosecution did not violate the principle of non-retroactivity of the law. Why then have former communist countries not seized these old and new legal opportunities to tackle the political crimes committed under communism, whose regular statutes of limitation had expired or were due to expire soon? Why did the anti-communist state narrative that characterized some of these countries, notably the Czech Republic, not translate into practical steps that could have brought more justice? Why did only the Baltic countries use this tool after 1989 in order to deal with the 1939 Soviet occupation? Why did we have to wait until 2014 to see the next country, Romania, invoke it in order to indict former communist leaders? And why is it still not used today on the large scale? And most importantly, could and should it still be? This workshop will endeavor to bring an answer to these and other questions by analyzing specific political, normative, historical, and legal contexts, if possible, in their mutual interaction. While it is centered on the Czech case, it is useful, as I already underlined, to have an interdisciplinary perspective and to compare the findings of historians, sociologists, and legal scholars, not only in the Czech Republic, but in other contexts. And this is exactly why I have invited Rivka Brod from Tel Aviv University. But before I even present Rivka, I have to announce a small change in the program. Christian Axel Nielsen will speak immediately after Rivka, while Lea David will speak in his place as the first paper of the second panel. So let me now introduce Rivka. She teaches at the Faculty of Law at Tel Aviv University. Her current research project, Law on the Road, Law in Jewish Displaced Person Camps in Germany, Austria, and Italy, 1945 to 1950, aims at exploring the perception of law in Jewish DP camps, camp courts, in the wake of the Holocaust, as well as the individual relationship with law in everyday life. Her book, In the Gray Zone, The Jewish Cappello on Trial, was published in 2019. And that's the book, the research I heard about that I found absolutely fascinating. It is a comparative study at the center of which are the legal proceedings of Jews suspected of collaborating with the Nazis held in the Jewish DP camps in Germany and the State of Israel. Rivka, the floor is yours.
Thank you. Good morning to all of you. I'm delighted to be here. I don't know any one of you, but Muriel, that we had the opportunity to meet in Tel Aviv, I think 2 years ago, something like this. I told Muriel that I feel a bit like a stepchild among you, and she reassured me that I am in the right place. So I hope that you will feel exactly like her. So I take you back to the post-Holocaust era, 1945, the American zone in occupied Germany. So the title of my presentation, The Cry for Rectification, is taken from a piece written in July 1947 by a Holocaust survivor journalist. The article dealt with the sensitive issue of Jews suspected of collaborating with the Nazis during the Holocaust, usually known as the Cappos. It was a call for inner communal soul searching. The cry, among some other factors, produced a unique Jewish legal and judiciary system composed of 4 different legal forms that Jewish DPs DPs, displaced persons, in the American zone of occupied Germany, established and operated between the end of 1945 and 1950. I chose the title, The Cry for Rectification, as a feature of the legal activities of the Jewish DPs, which raises various questions, such as how do residents of refugee or displaced person camps engage with legal practices and institutions? What was the meaning of law for people who were just liberated from 6 years under a terror regime, but still living within wired camps run by the American Army and international welfare agencies? What was the meaning of law for people running semi-autonomous communities with no state protection? The records show that although the Jews faced chronic insecurity, injustice, misunderstanding of their recent history, and its influence and anti-Semitic harassments both by the American and the German population around them, they extensively engaged in several aspects of the law. I argue that despite years of total absence of normative life, despite being subject to the American military government regime, and despite the loss of individual and community identity while transforming into administrative entities, displaced persons entirely dependent upon welfare organization, despite all of this, the Jewish survivors turned the DP camps into spaces of law. Furthermore, establishing and running multiple judiciary forums was also a means for personal and national rectification. So let me begin with a brief historical and legal background. At the end of the Second World War, about 10 to 12 million people found themselves in Germany and Austria. They were foreign workers, prisoners of war, and liberated prisoners of concentration camps and forced labor camps. Among those liberated in Germany, there were about 60,000 Jews. Until the autumn of 1945, the Allied Army succeeded in repatriating most people to their former countries. Most of the Jews stayed in Germany. They had no homes to return to and no places to go to. Due to a large influx of Jews who came to Germany from the Soviet Union and Poland, the Jewish population in the American zone grew and peaked at 200,000 people. They were scattered throughout the vast territory of the American zone in about 100 camps of different types. The establishment of the State of Israel in 1948 and the easing of American immigration laws led to the gradual emptying of the camps. The American Army, in its status and power as the occupier, was the sole sovereign in the area, applying its law to the entire population, Germans and DPs via the military government law and courts. Military government laws had various objectives that can be summed up as an overarching aim to restore the rule of law in Germany and assist the Germans in reconstructing a democratic state. Crucially for our understanding is the fact that the military government legal and judicial system was not meant for the DPs at all, Jews or non-Jews. However, living on American territory automatically rendered the Jews subject to the military government legal and judicial system that had no connection to or understanding of their specific situation as survivors of mass atrocities and gross violations of human rights. Despite the recent history and the excessive mobility that marked their lives, the records indicate that the Jewish DPs managed to build a remarkable community organizational structure that operated according to a political, cultural, and legal agenda. To understand the legal culture and practice in Jewish DP camps, here is a short description of the camp's institutional structure. Each Jewish camp was self-governed by local Jewish institutions alongside administrators appointed by UNRWA, the International Welfare Organization. The Jewish leadership of each camp formulated enforceable rules to run their daily lives. All the Jewish camps and the local institutions were subordinate to the central Jewish institutions located in Munich. It was a state-like pyramid structure. At the top of this pyramid were three central organizations located in Munich. The most important among them were the Council of Liberated Jews, the so-called legislative branch, and the most influential central body, the Central Committee, a sort of executive branch operating through a network of various departments encompassing every aspect of the lives of the Jews. Underlying the work of the central organs was a deep commitment to fighting for the Jews' human rights and their rights as a national collective. The unique institutional structure was the hallmark of the Jewish DPs that distinguished them from other DP nationals. One of the most impressive aspects of the Jewish DP's socio-political activities was establishing a complex legal and judiciary system. The beginning can be marked in the fall of 1945 with the establishment of the first Jewish court in the Landsberg DP camp. The primary reason for establishing this camp court was repeated incidents between Jewish survivors and identified former couples among the camp residents. Those encounters led to physical injuries and sometimes to near lynching. The camp leadership understood that it had to stop those incidents before more blood spilled. The answer to the high tension emotional situation was establishing a court that meant to transform the stormy emotions into rational discussions. The Landsberg Camp Court was the first, and soon enough, other camps followed it and established courts. However, adjudicating former couples was only one part of those courts' jurisdiction. Each camp court was authorized by the camp committee to decide so-called criminal and civil matters. They were assigned to judge minor offenses such as quarrels, petty thefts, libel suits, or violation of camp rules. And until March 1948, they were also assigned to pass judgment on identified Jewish couples. Jews who committed severe crimes within the camp boundaries or were caught committing any crime outside the camps were delivered to the American military police. Each camp court was also authorized to impose punishments. Most of them included social sanctions, such as removal from a position or denial of rights like cigarettes. However, most interestingly, the camp courts used imprisonment punishment, which the army strictly forbade, American army strictly forbade. Violating the military government law eventually led to a legal and political conflict between the Americans and the Jews, to which I will get back in a minute. What were the legal sources of the camp courts? Here is what the members of the Fernwald Camps Committee outlined as the legal sources for the court's judges. Legal concepts and laws from their countries of origin, legal ideas and unwritten rules generated by the daily lives in the camps, and directives issued by the Camp Jewish Administration and UNRWA. In other words, the local camp law was a mixture of the past and the present. Bear in mind for later the absence of any reference to the Jewish Orthodox law. The judges were chosen from among the camp residents, most of whom were not lawyers or with no legal education. Those who were lawyers before the war served mostly as chairman of the courts, prosecutors, or defense counsels. The second legal forum was the Central Court of Honor, located in Munich, being a central tribunal. This court was charged with preserving the integrity of functionaries with the various Jewish institutions, committees, and organizations that were scattered in the American zone. Maintaining integrity within the various Jewish institutions during that time was one of the main goals of the Jewish DP leadership. It was a part of their goal of restoring normative life. The third legal forum was the Central Rehabilitation Court. Located in Munich, this unique court was granted the sole jurisdiction over adjudicating Jewish couples. Until it started operating in March 1948, former Jewish couples, as I mentioned earlier, stood trial before the camp courts. From March 48 and on, it was the sole jurisdiction of the Rehabilitation Court, which was active until the last days of the DP camps. Despite the complex and the emotional issue this code dealt with, it is essential to know that it did not act as a field code that employed swift judgments. On the contrary, it acted upon a strict statute which dictated the rules of evidence, rules of procedure, and the substantive law. 3 judges presided over each legal proceeding alongside the prosecutor and a defense counsel. The court summoned witnesses to give their testimonies, and before delivering the written verdicts, the judges allowed the defendants to have concluding remarks. The statute also allowed reviewing the judgments in case of new evidence or miscarriage of law in the first instance. The court statute contained one offense only, collaboration with the Germans. The legal definition, which was formulated after long discussions by the Central Jewish leadership, was, and I quote, harmful acts against Judaism. I find it a fascinating statement on how the Jewish survivor perceived and understood both the meaning of collaboration and the crucial need for comprehensive communal accountability, as opposed to a personal one. The legal definition of the act of collaboration was meant to describe a deeper understanding of the behavior of the couples, not physical behavior, but the betrayal of the Jewish people. The various Jewish functionaries in the ghettos and concentration camps were considered to have violated Jewish solidarity and mutual responsibility. The Jewish leadership understood collaboration not as a private matter between a Jewish couple and his Jewish victim, as does the criminal law, but instead as an issue concerning the Jewish people in its entirety. This is a clear example of the use of law to reconstruct moral and social boundaries, not only within the DP camps. The Jewish DP leadership perceived itself as the emissary of the Jewish history at that crucial time, who committed itself to the task of reconstituting and rehabilitating Judaism. As the record showed, this court held about 200 legal proceedings before it ended its mission. The rabbinical courts, the fourth part of the general judicial system, dealt with family matters and other issues related to personal status according to the Jewish Orthodox law. I should mention that the mere existence of Jewish camp courts was not exceptional. Courts operated in many non-Jewish DP camps as an integral part of the local administrative management. However, the complicated structure of the Jewish judiciary, integrating various kinds of law in a local and central system, made it exceptional among other DP nationals. The question that had troubled me during my research was what was Jewish about those tribunals. They were all Jewish courts because they were established by Jews, operated by Jews for the Jews. They were Jewish courts in that they were established due to specific Jewish historical circumstances. However, they were not Jewish courts in the sense of acting according to the Jewish halachic law, the Jewish Orthodox law. On the contrary, the fact that these legal forums, except for the rabbinical court, of course, were secular, namely they had no affinity to the Jewish law, to the Jewish laws, was an unprecedented phenomenon in the history of Jewish communities and Jewish law. The wide-ranging legal and judicial system was administered by a central legal department, a sort of Ministry of Justice that acted through local legal departments established in the camps. Another aspect of the Jewish perception of law can be seen in the struggle or conflict between the Americans and the Jews over the camp court's jurisdiction. From the US Army's perspective, the legal status of the camp courts, Jews and non-Jews, was questionable. However, the Army turned a blind eye and silently allowed the camp courts to operate for reasons of convenience and recognition of the importance of those tribunals to the maintenance of law and order in the camps. Thus, usually the Army did not involve itself in the activity of those courts unless irregular activity was explicitly brought to its attention. This was the case that ignited the legal and political conflict between the US Army and Jewish DPs during 1946. The immediate cause was a trial held in one of the Jewish camps where a former couple was sentenced to 6 months in the camp prison. From the moment the Americans learned about it, the Jewish camp courts became the object of intensified army and military government investigations, not only about the use of imprisonment punishment, but also regarding their mere legality. The Americans strongly opposed the use of imprisonment, which they saw as the sole power of the sovereign, namely the army. Using confinement punishments by a court that was not part of the military government judiciary was considered an insult to their sovereignty. I should emphasize that the American position was not a purely legal one. Alongside the legal arguments, we can find political considerations relating to the new geopolitical circumstances, namely the beginning of the Cold War and the fact that the American attention moved from the general DP issue in Germany to the increasing tension between West and East. Within these frameworks, the Americans opposed the ongoing Jewish objection to assimilating into the German economy while maintaining their autonomy or semi-autonomies. The Jews, on the other side, rejected any other solution but the full power of their courts, including confinement punishments. The Jewish position might explain the fact that most of the documents I found in the American National Archives regarding this issue relate specifically to the Jewish camp courts, while imprisonment punishments were used also by other DP national courts. So time is short today to get into the depths of this intriguing political and legal conflict of jurisdictions. I would only say that the Jewish position represents a well-defined attitude about the importance of an autonomous legal system in the process of reconstructing both an independent political community and individual. Recently, I have revealed a new legal dimension of the Jewish lives in the DP camps, the free legal aid delivered to them by American Jewish welfare workers who volunteered with the Joint, the American Jewish Welfare Organization. This phenomenon, legal aid by non-Jewish welfare workers, challenged the general humanitarian policy by the Allies and UNRWA. This policy centered on providing basic needs such as shelter, food, clothing, and medical services. The Joint Relief workers were quick to identify the increasing gap between those basic needs and the difficulties and obstacles posed by the day-to-day interactions between the Jews and the Americans and Germans. This gap called for a different kind of welfare assistance, the free legal aid. Free legal aid by welfare workers can be summed up as representing and protecting the interests and human rights of the Jewish survivors. I should add that while this legal historical chapter disappeared from the Jewish and the Joint's historiography, nowadays legal aid by non-Jewish welfare workers is a common practice among NGOs working with refugees. To bring this presentation to a closure, let me emphasize two crucial components of the Jewish legal lives I have just portrayed. The first one refers to the spatial dimension, the DP camps. A DP camps is a liminal space characterized on the one hand by a soft occupation regime, namely in my case, a military government rule, and on the other by a semi-autonomous community. This non-state space had no room for a positivist law. Instead, we are witnessing an intriguing process of self-creating law within the larger framework of military government law to which all the DPs were subject. This situation produced an exciting kind of legal pluralism regime. The second component relates to the law itself and its use. In a short interim period, the Jews constituted a kind of experimental project in obtaining individual and collective rights, employing the law, establishing a comprehensive legal and judicial system within a non-state socio-political framework was a part of their aspiration to struggle for the fate of the Jewish people, turning it into what they termed as a subject of the world history. Against this background, I consider the cry for rectification neither a weak cry of helpless victims, nor a cry of a for a third-party intervention. Instead, the cry and the turn to the law produced measures that, among other factors, transformed the Jewish survivors from victims to political individual and community in a post-genocide era. Thank you for listening.
Thank you so much, Rivka. This was really interesting. I will have so many questions, as I'm sure we will all have. I suggest we start the discussion of both papers. You can both those who are present on the screen and those who are just attending can ask questions. If you're not, if I cannot see you, just send it in the chat and I will see it, I guess. And the others can just speak. Who would like to start?
May I maybe ask a question of Rivka's presentation?
Of course.
So again, Rivka, thank you for a really fascinating presentation. I noticed the emphasis you placed on the collaboration between Jewish survivors and legal advisors, and how they were learning about crimes against humanity, how they were learning about the law in these camps, and the way in which they were educating themselves and also being educated. I wanted to just hear, because, and I'll mention actually a colleague here who is Czech, but who works on victimhood in Bosnia. Jessie Barton Hronešová is her name. And she's got a great recent book on victimhood and the way in which victims get involved in constructing their own identities in post-war Bosnia and Herzegovina. And I really see a lot of similarities between her research and yours. So my question is, in a way, were there any tensions between like the way in which these victim survivors wanted to understand the law and what they were actually learning about the law or being told about it? Another colleague of mine has used, in a Croatian transitional justice context, this term folk theories of law, which basically means that, we're not all lawyers, and I hasten to add, I'm not a lawyer either, but we have notions, right, of what we want crimes against humanity to mean. And then the lawyers come and tell us, well, it's not really what you think, it's kind of different. So I'm just curious to hear whether there's any tensions there that you identified.
Just if I may, Jessie will participate or come, but of course it's 4 in the US right now, so she found it a bit difficult to be there from the beginning, but she said she would try to be there later. Okay.
Okay, I'll try to understand whether, although I'm not sure my poor English is fit for it, but I'll give it my best effort. My research puts the victims in at the center, whether they were the leadership of the Jewish DPs or the so-called regular or ordinary survivors. Most of them were East European, were from Poland or the Baltic, mostly Lithuanians. So their legal culture was East European. So, but I'm not sure, and this is something that I asked myself many times. How much did they think about law? Did they put the term law or legal activities in front of them? I think life was much more stronger that to call it law or legal activities. I think they how shall I put it? I'll tell you a story. I once spent time in Yad Vashem archives, and I met a woman, and she listened to my talk with another person, and she told me that her mother was in one of the greatest or biggest DP camps in Germany. And I asked her, please ask your mother if she knew anything, if she knows anything about what I call the legal lives of the Jewish DPs in her camps. So she came back to me, and she told me that her mother never even heard that there were a court in the camp. She never heard of legal proceedings or about trying Jewish couples in the camp court or in the central court. And I told her, you know, for me, the legal lives was at the center of the lives of the Jewish DPs. So here you come and tell me that she didn't know anything about this subject. So I don't remember. I don't know if I can say that they wanted to understand the law, or they wanted to put some meanings into their lives. I think the leadership with the Jewish tendency to talk so much about anything and to write, they wrote their lives in the DP camp. So there is a huge archives about it. So you can see the discussions about establishing the courts, establishing the rehabilitation court for the Jewish, for the former Jewish couples. They did it. It was a natural part of their lives without putting any special, without calling it with special names. It was part of their lives. But you have to bear in mind that the law has a central place in Jewish communities back hundreds of years before that. So I wasn't surprised to realize that one of the first institutions that was established in the camps was the court. For having a court in Jewish life was the central. It was like having a school, a synagogue, and a court. So law was a central part of Jewish lives before the emancipation, where Jewish communities were almost full autonomy, and after the emancipation, where the structure of the Jewish communities changed. Either way, the legal life or the law itself, whether it's the Jewish Orthodox law or the law of various organizations, social organizations, or the law of the state they lived in, it was a central part of their lives. And I think the DP camps as a microcosmos of their former lives put the law at the center of it without even, I don't think they put much attention to this fact. I hope I answered at least part of your very interesting remark. And thank you for this.
Thank you, Leah. You have a question?
Well, it's more of a comment because Christian, I really enjoyed your presentation. Because you're not going to stay with us now, and I'm not going to talk about it in my presentation, but I think it is important to stress that almost everything, literally everything you said, you can also switch Croatia with Serbia and you will get very similar or almost the same narrative, you know, like primordial existence, collective enemy, everything you mentioned. Actually, we can find the, you know, using different tropes, maybe instead of Bleiburg, something else, but again, the same kind of, they didn't invent anything. But I would like to say that if there is one difference, and I think there are several nuances, of course, but one big difference, I think, is the Croatian diaspora. And this is something that we actually don't see in the Serbian case. The role of Croatian diaspora was much bigger than we actually, that was researched even. I know that someone is doing now research about it, and I heard that presentation and said, oh, this is completely something that I didn't have in mind. The flow of money, budgets, everything, and you know, not only places you mentioned, also from Latin America, this is also important part, and it goes back, of course, to this after the Second World War and how they emigrated those Ustasha to different places, and now they were waiting for, you know, additional 45, 50 years, you know, to have their comeback by getting their citizenships. They are all entitled for Croatian citizenships. They're paying money. They're, you know, so there is if there is one difference, I would say that is the one. So. If you want to comment it, I really enjoyed your presentation.
Thank you very much. I think that diaspora in this specific time, I mean, in the post-Holocaust era, after the war between 1945 and 1950 until the establishment of the State of Israel or the opening of the so-called American doors, I think that the attitude of the Jews for this interim time, and especially the place, living ironically among German population, their former perpetrators, and they call the camps, the DP camp, they call my or our transient apartment. So they lived for 5 years on, if you can say it, on their suitcases. But astonishingly enough, they treated this time, this 5 or 6 years, 5 years, they treated it as a full communal life. They established, so the diaspora, it was not something, there was a tension, some sort of tension between the aspiration to leave Germany as quick as possible, and that's why they fought, they demonstrated and so on against the policy of England of closing the gates of Palestine. But at the same time, they managed to build some kind of a copy of their ancient or before the war model of community. So I think that so they very quick, they stopped treating themselves as victims. They were agent people. They were agent political and legal subjects for themselves. So I think the idea of diaspora in this specific time is very special, but I have no knowledge to make some to talk about your topic, because I, unfortunately, and I'm ashamed to admit that I know nothing about it. So if I may, I want to have one remark to Christian presentation. Can I?
Of course.
Oh, okay. So what I found very fascinating is some kind of not in your central talk, but some kind of side remark. The flexible use of the term Holocaust. You say that they called what happened to I don't remember the name, Holocaust or Occupation Holocaust or something like this. And this is very interesting because on the one hand, it touches the long-lived or this discussion about the uniqueness of the so-called Jewish Holocaust. Are there any genocide that is similar to the Holocaust, and or the Holocaust was a unique massacre or unique genocide? Or can we call what happened to in other places, call it also Holocaust? So this is an ongoing discussion, and you in your Remembrance organization, I think you know very, very good about what I'm talking about. But on the other hand, it touches also the subject of memory law, because or especially the law that denies that forbids Holocaust denial, because on the one hand, in European it's very popular. Holocaust denial is forbidden, but you can use it on other incidents, so or other genocides. Or other gross violation of human rights. So flexible terms that I think ignites very thoughts about the use of term, or the use of terms that we are so quickly adapting. Holocaust, is it only Jewish Holocaust or other? I think it is very interesting.
Thank you. I see that James raised. Oh, sorry. Did you want to answer, Roman?
No. Thank you.
See that James has raised his hand.
Hi, yes, thanks, Muriel, thanks. Just picking up on a comment that was made by Rivka earlier, so the earlier discussion, and about this drive or need to eliminate the memory of other people's experience of suffering or crimes or genocide. There's another strategy, actually, which you can observe in Hungary, which is to assimilate all the sufferings under the banner of the nation. So to have a discursive strategy that includes the suffering of Jews and Jehovah's Witnesses and other minorities in Hungary into a kind of blanket idea of Hungarian sufferingness. And you can see this in the Museum of the House of Terror, where faces of the nation become nameless. They all become equal sufferers of the communist repression, but also Nazi repression, and so if you can effectively subsume all those sufferings under the umbrella of the Hungarian nation in this case, then you do the same thing. Essentially, you remove the distinct quality of the repression or genocide perpetrated against peoples on your territory. But just in relation to Christian's mentioning of Goli Otok, that's a really interesting point, because a Serbian colleague, Alexandra Đurić-Milovanović, has worked on double minorities in Serbia and Yugoslavia. And one of the other groups that ended up in Goli Otok were religious minorities, so Nazarenes and I think Jehovah's Witnesses, and so that were various ethnic groups. They were kind of transcended kind of ethnic distinction, if you like, but they were also some of the ones that suffered most in terms of internment in that period. So thanks.
Do you want to answer? Otherwise, I would have a question.
No, you asking me? No,
Oh, all of you. Yeah, I mean, both of you. Okay. So then I will ask my question. Thank you, James. Yeah, no problem at all. But we're here to discuss, so that's good. So I have one question for Rivka and one for Christian. For Rivka, I was wondering what happened afterwards when these Jewish refugees found their way to Israel. for those who had been condemned, so to speak, by these tribunals, I mean, if you can call them that, was there any legal validity to this, or any social stigma attached to what they were accused of in the DP camps? Just a second, I finished my question to Christian. I really like this notion of ontological security that you mentioned, and maybe is that the explanation why there is an incompressible, or there seems to be at least an incompressible period of time between the moment these acts were committed and the moment, how could I say, the society is ready to face them? Do we need this ontological security for that? And is it why some countries did it years later and other countries never did it? Is there any way ever we will be able to overcome this competitive victimhood symptom in any of the societies we study? So Rivka, if you want to start.
Okay, thank you. Your question is for another conference or another 1 hour lecture. This is the second half of my book, but surprisingly enough, when the DP camps were closed and the Jews were spread all over Israel, the United States, and other places, the issue of the DP camps kind of disappeared. It came back in around the 80s, but the legal aspects of their lives, although, as I said, there was a huge archive that they left behind them, the legal aspects of their lives in the DP camps was ignored. Until today, and this is some 10 years that since I started, not 10 years, less than 10 years since I started my PhD, that my dissertation, that I still don't understand how people wrote so much about any aspects of the DP camps, of the Jewish DP camps, and never mentioned even one word about the legal aspects. But I understand that your question is about the Cappello trials, which, is it correct?
Yes.
You refer to the Cappello. So they came to Israel as other survivors, and of course they were stigmatized from day one. And there were emotional incidents between former couples or other functionaries from the ghettos or the concentration camp and other survivors involving the police and so on. Very highly emotional encounters, and there are many stories in the papers of the time about incidents in restaurants, in the streets, in bar mitzvah, in weddings, and everywhere. But there was no special law to, so the police was invited, the police investigated people, but the police couldn't do anything because there was no specific law to deal with this kind of accusations. So only in August 1950, there was a special law, the Nazis, a Nazi collaboration punishment law was enacted. And right after it was enacted, there were about between 40 and 50 legal proceedings of these people, which this is the subject of my MA thesis and the second half of my book, because again, there was no research about this very, very interesting legal proceedings, and very interesting, not only interesting, but very highly political law. This Nazis and Nazi collaboration punishment law it is a very political law meant by the state to kind of how you say, to purify the country from those people who who behaved as traitor to the Jewish people. But all the legal proceedings that took place in the DP camps never mentioned. Israel is the Israeli state behaved as if it invented this issue of putting on trial the Jewish couples. The legal proceedings from the DP camps were never mentioned, and I am glad that my dissertation opened the door for new research and new interest in this topic.
Thank you. Okay, does anyone have any question left, or shall we proceed? Okay, I suggest we take a 5-minute break, coffee refill. And at the same time, I welcome Jesse, who is apparently woken up and joined us. So we'll leave, we'll come back, let's say at 11:45. We leave the channel open so we can have a kind of a corridor chat as if we were in a real conference. But don't worry, you can say anything you want, because also this will be edited out from the final recording. So this will not show up. So as for myself, I rush for coffee. See you here at 45.
Muriel, just 1 second. What's the new schedule? I don't have a copy of so what comes next?
The schedule is the same, except that Leah has graciously accepted to speak only now instead of Christian, and you're after Leah. So you are on for 12:05.
Brilliant. Okay.
See you all in a bit.
Yeah, see you in a moment.
Thank you all for your...
Yes, exactly. Yes, so not everybody's back, but I think if they hear talking in the background, I think it will make them come back faster, Leah. So just a second, I just took my chronometer to check the time. Yes, and I suppose you can start again. Okay. Oh, sorry, and I forgot to present you. My apologies. Let me find this. So Leah is a comparative historical sociologist with a strong interdisciplinary background in cultural anthropology and history. Her book, The Past Can't Heal Us, The Dangers of Mandating Memory in the Names of Human Rights. That is one of my favorite books of all times. Got published in 2020 with Cambridge University Press. Leah is a co-chair of the Critical Thinking on Memory and Human Rights research group within the Memory Studies Association. Her research interests cover memory and memorialization processes, nationalism, human rights, ideologies, solidarity, activism, the intersection between the Holocaust and genocide, and conflicts in the former Yugoslav countries and in Israel, Palestine. Another comparison I'm very fond of. Leah, please.
Okay, thank you for this invitation. I just want to start with what Rivka said, that she feels like a stepchild in this conference. So I think by the end of this conference, we're all going to discover that we are stepchildren. And in a way, I also feel like I don't fit, because this is not my prime research area at all. However, I think there are other ways to look at this, and I'm really really happy to be here because this is also my opportunity to learn much more about this topic. So I want to go back to actually this main question that Muriel posed, and which is how come that we have such a weak response, legally speaking, or even interest in those crimes committed in communist or during communist regimes. So I want to offer here two different answers to this question. And one is, I will start with something that is maybe closer to what Christian was talking about, but maybe from a different perspective. So first, to say, just because we're not using PowerPoints, I'm very, very happy about that. I'm just improvising everything, so it is going to be not structured at all. But I hope that at the end of the day, you will understand some of my points. So there are two reasons I want to present. First reason is something, as I said, goes back to what Christian was saying, those political reasons or things that happened since 1945. And the other reason is just to bring something that has to do with the logic in the way in which we understand today past, facing the past, and all those processes that are related to human rights and transitional justice. So what do I mean by political reasons? Of course, the story about post-communist crimes cannot be the same in different post-communist settings because of what happened after 1945. If we talk about Yugoslavia, we can talk about many different forms of communist crimes. And again, Christian mentioned Bleiburg, and there are many others. So if we talk briefly about different phases in Yugoslavia, we can say at least, we can talk about at least about three phases. One is from 1943 to 1948, where we have those kind of state, republic, and provinces commissions that were built to bring everything that we know and that were called like national or people's traitors to the justice. And this was, of course, a very oblique process, because we see, for example, that there were more than 66,000 files and decisions on different people during that period. Out of that, we see something like 17,000 was about foreign people, and something like 50,000 about domestic traitors. But who were those people? These people, it's very broad category of people, those who collaborated, those who were politically not suited, those who had different political agendas, or, you know, just a lovely neighbor that you didn't like, and you use that opportunity to get rid of him or her. So, of course, those decisions were mainly brought to the fore by people who had power, and they decided actually who is going to be named as a domestic traitor. Of course, we talk about a huge percentage, especially in the years after the end of the Second World War, of Italians, Germans, and Hungarians were prosecuted. If we take, for example, just Germans, they were living at that period around 150,000 Germans in Vojvodina, and out of them, 80 to 90% in 1945 went to different detention camps, and out of them, something like 46,000 died. But, you know, this is something part of this old history, and we can call it as usual casualties of war, and there is no one to talk about it. Now, second phase that was really maybe most prominent was this phase of Goli Otok, which was an island in Croatia that operated fully as a detention place from 1949 to 1956. And we have something like 16,000 people who were expelled there. again, those are people who were found in those decisions to be traitors, many of which never understood how come they ended up there. So we are talking about secret files, we are talking about procedures that were not transparent, not open. The same story that goes actually for many of other communist places in that and later period. And then somehow, you know, it has to do with Tito and the whole history with his history with Stalin and saying this famous no to Stalin. But yet again, this Goli Otok prison was operating at some capacity until 1988. And the third phase, and this is something that Christian was talking about, is this phase that came about and came during the wars of the 90s and after, especially after the wars of the 90s, where we see the huge rehabilitation, especially in the Serbian case, rehabilitation of Chetniks, in the Croatian case, rehabilitations of Ustasha. They all get those privileges and this is funny, under this pretense of let's try to forget what happened in the past. Let's bring what matters is that we are all Serbs. We all fought for the same thing. It doesn't matter if we are talking about communists or we are talking about Chetniks or Ustasha. So it is time to have this reconciliation. And this is important because the language that is being used is actually language that was taken from this vocabulary of human rights. So bringing and doing actually rehabilitation of Chetniks and Ustasha is being promoted as a project of reconciliation, where we put everything, all the differences aside. And as Christian said, you know, it doesn't matter who went to bed with whom. What matters is that we have those healthy children that are all either Serbs or Croats or whatever. Of course, another aspect that has not been discussed enough, that is the role of the Catholic Church, as well as the role of the Orthodox Church, also during this period, and of course during the period of the wars of the 90s. So when I say political reasons, I mean, especially for places like Yugoslavia or ex-Yugoslavia, so many things happened after that, that this is just one layer that in comparison to other things that happened is not that bad. And most of those people actually have died, and even those who survived have no political power actually to fight for their own cause, especially because there are so many other things, so many other types of victims that are more visible, more present in today's political space, that there is no political point to do anything about this. And this brings me to my second point, to this logic. And here I rely on my book that Muriel mentioned, the Past Canhilas, the dangers of mandating memory in the name of human rights. How we came to think about past the way we think today. And I think this is very important because we often use this vocabulary, but we are not aware that we are actually just going through those paved scenarios that are put in place for us by all kinds of historical and sociological processes. So I write in my book lengthily about those three processes that actually brought today what I call moral remembrance, or the human rights memorization agenda, that has three basic principles. One is duty to remember. We all as collectives need to remember past or whatever, you know, human rights massive abuses that happened in the past. Second is facing the past. We as societies need to face the past. We need to understand what actually happened. And the third is that our understanding of the past has to be victim-centered. So all those three approaches have very distinct sociological and historical trajectories, but somehow due to different processes, and whoever is interested can read it in a book, how that happened, they came together and they became this foundation of the human rights memorialization agenda, and consequently also of the vocabulary that we are using today, and blueprint of practices or toolkit of practices that we have today to actually deal with all kinds of difficult pasts. So in my book, I don't talk explicitly about the communist crimes, but I want to maybe use this opportunity to explain actually how this logic affects today our understanding of the communist past. So as I said, those three principles have very different roots and pose different duties on society, both societies and individuals. But what is important in this context is this metrics that has been adopted by human rights, by the human rights regime in general and human rights organizations, that there is this ideal type, metrics between victims, perpetrators, and bystanders, which, by the way, goes back to the experience from the Second World War, how we understand who are those victims, who are perpetrators, and who are bystanders. And even if we talk largely about, again, Christian mentioned Jelena Subotic and ontological security, if we talk about Europe, we certainly can say who are now bystanders and how come we see the European Union doing all kinds of things from the place of bystanders and this guilt of understanding we cannot be passive anymore. I mean, I can go with that trope much more, but you understand the point. Then we have perpetrators, those who committed crimes, and we have victims, those who are innocent and suffered those crimes. The problem with this simplified metrics is actually that it brings what we already mentioned in a previous session, is this hierarchies of victimhood. Who is more victim? How can we know? How can we measure? You know, how can we say you are more victim or who is more victim? So, of course, those mechanisms are well by now, I think, researched, and we see all kinds of things that are coming under this politics of victimhood, because the fact is that once societies or segments of societies adopted this human rights memorialization agenda, they also adopted this idea that there is this ideal victim. Ideal victim is, of course, something that has its roots in the Holocaust, in a Holocaust victim. We know even to sketch imaginary imagery around it, so we know how to actually say who is this pure victim. The victim has to be someone innocent. And the problem with this, first of all, it is very static. So we take people only because of, we call them victims only because of something that happened to them, not who they were. So we freeze their lives only on one aspect at the moment when actually they died or brutally died, or when they were in this status of victims. Second thing is that we actually created this scene in which victimhood is understood as a new heroism. Victim is a new hero. You want to be presented as a victim. You want to get this this badge of honor that you're a victim, because it brings all kinds of, it opens for you all kinds of doors. You're in a good place, you can get some reparations, you can get symbolic or tangible benefits, you get a stage to talk, and you get empathy. You get actually out of it much more than today. Hero is underrated completely. So there is, with this logic of the moral remembrance, we see how victimhood became such an important player in a domestic and international politics. In domestic, because we have victim organizations and individual victims who are trying to promote their own victimhood as an ideal victimhood, which, by the way, in the process of that, of making this victimhood, we actually see how people are being reduced, their identities are being reduced. They need to fit to this image of ideal victimhood by censoring, making a censorship of their own life stories, raising all complexities just to fit to this certain position of victims. Several years ago, I spoke with someone who is doing research in Bosnia with people, with women who were raped, and she told me they're not allowed, they don't want to, they're not allowed to say I remarried, because it takes off from their victimhood status. So they always need to actually keep that and leave that status alive. So it is actually living their life backwards, not forward. You know, there are many issues and problems that come with this simplified logic of victims, perpetrators, and bystanders. Of course, if we talk about victimhood at a political or state level, we see how different entities are always trying to fight to present themselves as the biggest victims of them all. Again, if we go back to this to Christian's presentation, whether we are talking about Croats or Serbs or Bosniaks, we have the same pattern of political elites actually adopting this notion of victimhood, again, as a badge of honor, and trying to equate it, again, learning from the Holocaust experience, how to promote and how to get out of it the most at the international arenas. So it is, there is nothing naive about it, and it has many political consequences, this idea actually to have victims. In that sense, sorry, in that sense, and again, I want to go back to this hierarchies of victimhood and competition over victimhood and the use of numbers. I think it is important to detach this or to try to think about this subject from a different angle. We see what is happening now with Corona and with the different measures around the globe, and we cannot stop thinking and asking how come if the threat is the same, we have so many different responses, and of course the answer to that is politics. But one important thing I think that is not being talked about enough in this context, and it has implications to this competition of victimhood, is the use of numbers. The use of numbers and power of numbers is really important. And we can see from the beginning of the pandemics how everything we know about Corona was quantified. So we had numbers, numbers about that, numbers about those who were infected, numbers about different cases. Everything was about numbers. And this is important because numbers have a really strong effect on us. So it is interesting also to say how different people and different cultures understand different numbers, because numbers are actually forcing us to different behaviors and different emotions. So when we say Bleiburg was bigger than XYZ, or the number was, is it important that the number of people who died in Jasenovac was 70,000 or 200,000? So you have to ask, so what is about those numbers that is 70 is not enough? 7,000 or 8,000 in Srebrenica is not enough. Why do we need this inflation of numbers? So it goes again back to this competition of victimhood, where numbers are used as a powerful tool to actually dictate our emotions and our behaviors. So this is very important, because if you compete now Bleiburg of several thousand and Holocaust of 6 million, well, you know who is the loser. So it is not about the quality. It is not about the suffering. It is not about those who died. It is only about the effect, political effect in real time and real life. And I want to finish with one observation to bring this back to our topic of today, post-communist crimes. The problem with these metrics, and there are many problems, as I already suggested, but one of the problems that I think it is really clearly reflected in the way we understand today communist crimes is that communist crimes are not sexy. They cannot be reduced to this ideal type. They cannot be reduced to, you know, people who were executed in front of cameras, mass graves, detention camps. This imagery that we can use is very limited. We know it is something that is like a backstage, something happened. It's a hush-hush crime, but we don't know because we don't have enough information. We don't have enough information because information is not available to us. So, and then again, each case might be different. You know, we don't actually know what, maybe they deserved it, maybe some deserved it, maybe no one deserved, but we don't know. So don't know, this state is actually making us not being able to recruit ourselves emotionally into this story. And when you're not emotionally recruited, you are not likely to do anything about it because you cannot, there is no some mechanism that you can actually project empathy or you can understand what happened there. So it is something that is like a dirty laundry. So you don't know what is there and you don't want to touch it. So this is what is actually happening in many places that not like Yugoslavia, but that didn't have those violent experiences afterwards, but were actually established democracies. And you would say, but we have legal mechanisms. We have ways to do something about it, and still nothing is happening about that. That is one thing. And the other thing is, once you don't have actually this emotional recruitment of people or people who can identify or understand, okay, those were the victims of those crimes, you don't have agents, you don't have people who are going to fight for that. It is going to be on the it will stay on the margins of a scholarly discourse. Maybe even it is going to be a legislative issue, but still not more than that. We see, and I will finish with this, in the recent week in Albania, they actually said that they cannot prosecute crimes committed during communism because those were not criminal crimes, but administrative. So there are no courts actually to deal with it, and it is just waste of time to deal with it now. So there are many reasons why actually we are in this state of mind today. And we can talk about it much more. I hope I managed to make some points that make some sense. Thank you.
Thank you so much, Leah. As always, fascinating. I love it. We'll have many questions. And let's move straight onwards towards James. So James Cappello is a senior lecturer in the study of religions at University College Cork in Ireland. He was a personal investigator of the European Research Council Hidden Galleries, a fascinating project that I had the chance to observe several times from close by. That was really great. It focused on the material and visual presence of religions in secret police archives in Eastern Europe. He is co-editor of The Secret Police and the Religious Underground in Communist and Post-Communist Eastern Europe, together with Kinga Povedak, that was published earlier this year. James.
Great. Thank you very much, Muriel. I think everybody that's spoken so far has kind of indicated that they're somehow beyond their comfort zone or out of their depth. Me more so than anybody else that's spoken so far, and I can guarantee that.
Me the most.
So I'm a scholar of religions, as Muriel introduced there, and my interest in communist crimes, if you like, has come from the perspective of a scholar of religions interested in things like religious transmission during communism. For which reason I went to the secret police archives and discovered this rich body of evidence. We could call it evidence, evidence of the crimes of members of religious communities as perceived by the communist regime, or at least the dangers that they perceived amongst those groups. But also for a scholar of religions, it's how to use that evidence as somehow evidential for our scholarly activities as historians of religion or historians of communism. So in my paper today, which is, again, it's going to be a bit more of a comparative sketch than a coherent argument. But I'm going to touch on actually three things just mentioned by Lee there. She talked about the availability of evidence. So that's kind of at the heart of what I'll be talking about. And who deserved repression. So this idea that perhaps those that we don't know about, perhaps they deserve to be repressed or persecuted, and about the idea of who is emotionally invested or can be emotionally recruited into any kind of pursuit of crimes during the communist era. So, as I said, this is way beyond my comfort zone. I'm relying heavily on some Romanian colleagues and friends of mine, Lavinia Stan, maybe some of you know, Monica Ciobanu, the work of Cristina Petrescu, and Igor Casciu, a Moldovan historian. So I've kind of cobbled together what they've had to say in the light of my own archival experiences in Romania and in Moldova. So that I'm going to make a kind of a comparison today between those two situations. But I've also got experience in working in Hungary and a limited extent in Ukraine too. Okay, so in November 2019, the trial of the former Romanian President Ion Iliescu got underway in Bucharest on charges of crimes against humanity. Tellingly, his trial relates primarily not to crimes committed whilst he was a member of the communist elite in the 1960s and 1970s Romania, but to his role in the very moment in which the regime was overthrown in December 1989 and the aftermath. So he stands accused of creating an atmosphere of terror using secret police agents that in the ensuing chaos directly or indirectly resulted in the deaths of hundreds of people during his grab for power in the days of the revolution. The trial of Iliescu, following many, many twists and turns, looks likely to be abandoned now. In Moldova, the moment and the aftermath of transition has also shaped perceptions of what constitutes a crime or what is worthwhile pursuing as a crime in relation to the past. Moldova's brief armed struggle against Transnistrian separatists in 1992 resulted in new human rights abuses, including casualties, of course, on both sides, as well as abuses perpetrated after the war by the Transnistrian authorities, which have imposed a kind of dictatorial state in Transnistria. So these more recent violent episodes, as well as the key individuals involved with them, in both cases have played a role in complicating the prosecution of crimes committed during communism. So, as I said in this paper, I'm going to do a kind of comparative sketch between Moldova and Romania in relation to the significance of secret police archives. So, of course, reckoning with the past has both judicial and non-judicial forms. In this paper, I'm going to deal really with the significance of the secret police archives for these non-judicial questions. How the opening of the archives or the remaining closed of the archives has shaped the possibilities of various ways of reckoning with the past and various transitional justice measures. And so I'm really talking about it in terms of kind of social memory and the experience of ordinary citizens in relation to the archives, and the influence this has had on scholars working in those archives. Okay, so hopefully these points will give us some insight into this question of the use of crimes against humanity for reckoning with the communist past. So I'm not going to talk explicitly about any trials either in Romania or in the Republic of Moldova, or how secret police files were used in any trials that were pursued, but more about how indirectly the secret police archives have impacted on society, both groups that were targeted and groups that weren't, and how this has influenced the possibility of approaching those crimes. So what I've got to say was really heavily influenced by a brief conversation I had with a colleague who works on the politics of memory in Spain, where, I mean, she spoke about the failure to pursue through the courts the criminal acts of the Franco dictatorship, really transformed or shifted the social narrative frame in Spain, especially the latter years of the Franco dictatorship, was successfully shifted the frame in such a way that kind of brutal crimes became inexhumable from the past, lost, buried deep, and inexhumable. And in some sense, this is also applicable to the case of Romania and Moldova. So the passage of time really matters, and the experiences of those that experience transition and are living in societies currently. They're really the two most important points I'm going to make in the paper. Okay. So, like I said, I'm going to compare Romania and Moldova. But as Lavinia Sana said, few post-communist countries are truly comparable when it comes to the relationship between historical experience and the implementation of transitional justice measures. However, my experience in working in Romania and on the archives of Soviet Moldova, and of working with contemporary communities, how they remember the past, I think can shed some light on this problem of what you know, the drive to prosecute members of the earlier regime. Of course, in both Romania and Moldova, the possibility of pursuing crimes through courts has been linked to post-communist political power, and that political power has relied on notions of truth and justice that relied heavily on secret police archives for their kind of evidential support, if you like. The archives have a kind of peculiar paradoxical hold on both societies, more so Romania, because of the public consciousness of the secret police archives and the long struggle to open the archives. So there's a kind of recognition that what the archives contain, even though it's tainted ideologically, is the result of kind of social engineering projects and illegal or immoral sort of actions. Nevertheless, the power of secrecy, the power of the hidden nature of the archive, really influenced the way that Romanian society especially viewed the possibility of those archives and the truths that they might hold. And has kind of radically, if you like, reshaped historical memory and social narratives. So I'm going to speak about each country in turn, first starting with Romania. Public access to files was primarily aimed at addressing the experience of mass surveillance during the latter decades of communism in Romania. This is a really important point. The drive to open the archives was not really focused on the crimes committed in the earlier Stalinist period, if you like, in Romania, but really focused on the immediate sort of pre-revolutionary period, or at least the 2 decades before the revolution, when surveillance, mass surveillance, characterized the Romanian regime. So, I mean, if we were to sort of divide the Romanian experience very, very roughly into two periods. You have a Stalinist period from 1945 to 1964. After 64, you had amnesties where prisoners were released, but during that period that you had, you know, mass murder, torture, labor camps, systematic campaigns of terror, and so on. And then you have a latter period, which is kind of a national communist period under Nicolae Ceausescu, when vast numbers of citizens were placed under surveillance. People became very, very dependent because of the all-pervasive nature of the regime for their livelihoods, on their sort of ability to use their contacts and so on, during increasingly difficult economic circumstances. So the kind of nature of this later communist regime, which again I'm quoting Lavinia's here, was characterized by ubiquitous and insidious secret informers, in which citizens survived by keeping silent, accepting manifold compromises, negating their basic moral principles, turning a blind eye to injustice inflicted on relatives, neighbors, and friends, downgrading their own life expectations, and living parallel lives of solitude. I think she captures it very well there. And there's an important point there about turning a blind eye to injustice that is extremely relevant to when we start to look at what happened in the post-communist period. Cristina Petrescu makes a really, really important point in her discussions about what constituted dissent in communist Romania, when she says that, you know, that the degree of violence perpetrated by the communist regime in the first decades was largely unknown until after 1989. So the regime had been very, very successful in burying the earlier sort of experience of crimes, even though during the Ceausescu regime, some novels came out, some even filmic representations of Stalinist crimes. They were kind of, you know, they were dramatized, if you like, for mass consumption and assimilated. But I think the people's experience of later communism, the wave of euphoria that followed Ceausescu's sort of stance towards the Soviet Union and in relation to the Prague Spring, meant that, you know, the kind of public understanding of Romania's place in society, and also the generation during that period of external enemies of Romania, that Romania is surrounded by enemies, including the Soviet Union, but also Hungary and other communist states, and also the West, successfully reshaped the consciousness of Romanian people in relation to, you know, what their regime stood for. So this whole process is significant, as the opening of the archives, which was meant to address this later period, which ended, of course, with the swift trial and execution of Nicolae Ceausescu, deflected attention away from this earlier period, the Gulag period of kind of forced labor and so on, and also succeeded in ingraining in the kind of Romanian people's consciousness the idea that the abuses of the regime were associated with a single individual. That single individual was not systematic in his abuses against the population, but was, if you like, abused the system for personal aim and personal benefit. So it was not really, the regime came to be considered to be one of abhorrent excesses, if you like, of the Ceausescu family, and not of systematic crimes. There was a kind of even, you know, in the immediate post-revolutionary years, an understanding that the Romanian regime had done what was necessary for its patriotic duty. So there wasn't really a questioning of the patriotism of the communist elite. So the regime as a whole managed to avoid being portrayed as the root cause of abuses, and the new post-communist leadership, which of course was made up of many key figures from the earlier communist period, positioned themselves also as victims of the Ceausescu regime. This was one of Iliescu's key abilities to do that. And this delayed the call for the opening of the secret police archives, and also gave the opening of the secret police archives a really, really political dimension, as actually all of the forces, the political forces immediately after the Romanian Revolution had an interest in not opening them. One side had an interest in portraying a desire to open them. The other one, the kind of post-communist elite, could explicitly argue against it. But ultimately, this created a delay. And to cut a very, very long story short, you know, it was 1999 before the archives began to open to ordinary citizens. I'm not going to sort of detail all the kind of the laws of access and so on. And it wasn't until 2006 with new President Traian Băsescu who kind of ordered the transfer of 1 million files to a new council that was set up, the Council for the Secret Police Archives, CNSAS, as it's known today. Importantly, Romania decided to grant access to ordinary citizens as part of that process, which again, you know, is a kind of uniquely Central or Eastern European way of dealing with the past. It's not a process that's been engaged in sort of globally in other transition contexts. And the kind of the momentum that would have been produced, if you like, by truth commissions or kind of top-down judgments on the regime was actually subverted, if you like, by a bottom-up interest in what was in the secret police archive. So a genuine kind of societal level curiosity, obsession with access to files and understanding what was in your file, but not because of you know, an idea about the excesses or the abuses of the regime in early decades, but more to do with very, very recent experience of citizens who were under surveillance by their neighbors and friends and so on. So the evidentiary value of the secret police archives for crimes has been masked, if you like, by this other value that was posted on them, which is really to do with the uncovering of abuses that couldn't really be pursued as crimes, if you like. They were abuses that were much less sort of identifiable as key crimes that could be viewed through the courts. So the obsession with secret informers is key to this. What tended to happen was that individuals that were identified through secret police files as secret informers, because they were secret and they were being revealed, that became a really, really potent symbol of the change of regime, rather than the pursuit of crimes of individuals that were known pre-revolution, so generals or you know, high-level politicians, or even the secret police agents themselves. Which again, you know, people generally knew who they were, the captains and generals in the secret police. They were uniformed officers, their identity was known. Those that were not known were the secret informers. The uncovering of secret informers became a particularly powerful factor in post-communist society, because those that had been secret, you know, through the act of self-confession, for example, were able to exonerate themselves. And in doing so, they created capital, social capital, especially in relation to religious leaders. There's one very famous metropolitan called Neanu who very early on confessed that he'd been an informer. And because he confessed early, everything he then said carried weight. He was considered to be an honest and important commentator, if you like, on the communist period because of his confession, and people overlooked what he'd actually done during communism. Whereas those that had to be discovered through the archives and revealed, they lost face, and they became the primary losers, if you like, in terms of social capital, and not because of the real impact of what they'd done, but through the different kind of processes of revelation, whether the files have been used to reveal you, or whether you've revealed yourself. This became really, really crucial in terms of how society accepted them. So it was outrage that followed the disclosure of informers' names, was completely disproportional, if you like, to the damage that was inflicted on victims by those people. Okay, so that's the Romanian context, very, very briefly. Now I'll switch to Moldova. I'm probably going to grossly run over time, Muriel, but I'll try and cover the Moldovan case as briefly as I can.
Yeah, actually, you're already speaking 20 minutes, but on the other hand, we're not really in a hurry, so you can take another.
I can just go on. Okay, very good. So I'll do this very, very briefly, put the paper aside and just tell you about the Moldovan case. The Moldova is very, very different. It's an ex-Soviet republic. One similarity that we can identify is the fact that the Soviet regime, like the Romanian regime under Ceausescu, was very, very successful in instilling in the population an idea of the reality of the threat that was posed to the Soviet Union, that the civilizational value of Soviet society, and the real danger that was posed by external threats and internal enemies. So after the end of the Soviet Union, most of the KGB files were sent to Moscow, or indeed to Transnistria, to the breakaway sort of region. So file access is very, very different. File access has come about, but not in a general kind of process of making them easily available to the general public. First of all, they were made available to a body of historians who were entrusted with sort of compiling a record of the crimes of the communist regime. And then a larger body had been transferred to the National Archives. The files in the National Archives overwhelmingly deal with, there's about 25,000 personal files, case files, relate to the earlier communist period. So they relate to the kind of crimes of the Stalinist era. And this is really my key point. When I say they relate to the crimes of the Stalinist era, the files are criminal files pursued against enemies of the Soviet Union. And the perception in society of those crimes is still alive today as genuine crimes. So the emphasis immediately, in the post-communist years was twofold. One, the immediate crimes that had been committed during transition and the Transnistrian breakaway republic, and the deaths and the pain that was caused there. And the other was actually overturning the legal status of the crimes that people have been accused of having committed. And now I'll just give very, very briefly one case study. One of the religious communities that I've worked on a lot in that period, 1940s, 1950s, were accused of some of the grossest kind of human rights abuses of mass forced starvation of their own members, of child murder, abduction, rape. And this community, in the KGB archives that we have available to us, were prosecuted, but not for that. They were prosecuted for anti-Soviet activities, for obstructing grain requisitioning and struggling against the establishment of community farms, kolkhozes. So the opening of the archives, which some historians had access to and were subject to judicial review, overturned crimes that were present in those archives that were actually didn't relate at all to the public perception of the crimes of the enemies of the Soviet state, which were perpetrated or published in propaganda campaigns, mainly in the late 1950s and 1960s. So we have crimes against anti-Soviet agitation and crimes from the 1940s that in the 1960s are portrayed as these gross, violent, abusive crimes of charlatan religious leaders who killed their own members and murdered their babies and so on. And in the post-communist era, it's that memory of those crimes that needed to be overturned. And so that's where the emphasis came in the Republic of Moldova, overturning the false ideas about the crimes that members had committed, and not in actually pursuing those people that were responsible for the mass deportations that took place in 1949 and 1951, or indeed the famine that Moldova experienced between 1946 and 1947 into 48, which in many ways, you know, parallels the Ukrainian experience of the Holodomor. The irony of this situation in relation to crimes is that the very communities that were sent to the Gulag were the ones that were accused of having caused the famine. And so in the pursuit of today, for historians, in the kind of pursuit of truth around the causes of that famine, this may well be the area in which we can see a genuine recognition of communist crimes, and perhaps even, who knows, in decades to come, a pursuit of crimes against humanity for those that perpetrated that aspect of the famine. But that becomes purely off the back of the recognition, and I think, you know, historians in Moldova are really important in this case, and my own work on religious minorities, in demonstrating that the victims were accused of being the victimizers, and you know, we need a really close examination of the historical context to sort of unpick that through the secret police file. I'm going to jump to just a few concluding remarks. So to go back to, I think what Leah was saying there in her talk, you have this in relation to secret police files in Romania and Moldova. There's this relationship between recent experience and how that shapes social memory, and the emotions that go with that, the emotional investment, if you like, in any kind of pursuit of justice. You have a lag or delay in the beginning of the transitional justice process, which means that, you know, things become sort of fading back into the historical time, and momentum, you know, priorities change, and so that when momentum is gained, it's actually for a different pursuit of a different set of goals. And then the paradoxes of the archives themselves, which are both seen as a site of kind of a guarantor of truth, but actually they're also, you know, they're distrusted. So there's a paradoxical relationship to those files. So I mean, I'll end there. I'm not sure if the argument was particularly coherent, but what I was trying to do is track the difference between two different contexts: one with open archives, which has resulted in, you know, a failure to pursue crimes against humanity for the earlier communist period, and closed archives, which has also resulted in the same kind of outcome, roughly speaking.
Thank you so much, James. Yeah, and you even managed to speak quite a bit in the end. You see, you were afraid of not having enough to say. So let's discuss the two papers. Does anyone have any question to start with? Roman, you're raising your hand?
Yes, if I may. I have a question to Leah. I would like to ask her a question which is really not fair in a way, because it's not the topic of her presentation, but she brought a very interesting point about victims' agency and to what extent victims are agents themselves to retain their victim status. This is something which is quite important in many aspects. One of those aspects which I would like to ask a question is, the victims are obviously the kind of the social construction of victims is, you know, that they are passive, and if they are victims, that they should not do anything. But I still cannot reconcile this this concept with my understanding and belief in people's human agency. And the question which I have is, why do you think there were no civil law lawsuits, or at least perhaps almost no civil law lawsuits brought by victims in post-communist space, brought by victims against perpetrators, against informants, because they are in many cases quite identifiable people. It looks like that, you know, this whole issue of dealing with the past has been pretty much centralized. But the issue is that, you know, nobody prevented victims from, you know, filing their lawsuits, you know, against the perpetrator. So is there anything to do with the victim status, or, you know, that, or why do you think this could be the case?
Okay, I can divide my answer into two. First, about victims' lawsuits and about communist crimes. I have no idea. I didn't say they didn't exist. That's not my area. I really don't know anything about it. So let's put that aside.
It's unfair. Yeah, I know.
I mean, but about victim status, again, I'm talking about this historical process in which we understand at this current moment victims as a certain political subjects. And yes, you're right. The way we understand them today, and Jessie, I know that she will be able to talk much more about it, is actually that we take away their agency. And we understand them as passive. You know, someone else needs to talk in their name. Someone else needs to say something. Whereas actually victims are trying to regain that voice. There is something paradoxical about this way in which that is very much influenced by the understanding or our knowledge from human rights and transitional justice, that, that on the one hand, everything is there. The whole idea is actually to give voice back to victims, but we end up actually taking their voice away from them because they need to be presented and preserved under certain status of, you know, I need to be victim in only, you know, I cannot bring anything that is messy and complex, because then I'm not a perfect victim, and I need to be a perfect victim because there is a politics, day-to-day politics, how I'm going to gain or how I'm going to actually claim my benefits. So there's real issues here that are dealt on a daily basis politics. So it is, again, it is a bit of oxymoron, and it is very difficult to break through this concept. And, you know, I'm a victim, but still I can talk. Yeah, again, Jessie, I'm sure that Jessie has more clever things to say about it because she wrote a great book about it. So, yeah.
Jessie, if you want to intervene.
Thank you. And thanks so much for letting me participate. It's early morning here in the US, so I do apologize. I just joined you late. But thanks, Lena, for putting me on the spot. But I actually had a related question / thought related to this. So when we talk about war crimes, there's this huge discussion, especially in gender studies, about the term survivors versus victims. Whereas when we talk about communism, it seems that most of the time we talk about victims. And I think that goes to what Lea was saying in her presentation as well, that I think as anyone who kind of lived, you know, through the periods of socialism / communism in Eastern Europe is in a way a survivor of that, or could be, you know, could claim that status, if you like. But it's only those who were really, you know, put in camps or who were one way or another persecuted that use the term victim. And so it's quite rare that we would actually talk about crimes of communism and talk about survivors. We tend to talk about victims. Whereas if you talk about what happened in the former Yugoslavia, you would have a lot of these victim organizations, I call them victim organizations as well, that especially those that survive sexual violence would make adamant claims towards survivorhood because it's more empowering, it gives the agency, et cetera, et cetera. And there's a huge discussion, and there's a huge debate, and pretty much anyone who now writes on transitional justice on anything related to victims would have to have at least a footnote that would have to do something with, okay, how do I use the term survivor versus how do I use the term victim? But what is interesting, and that is related to what we're just talking about, is that the moment these victim organizations / survivor organizations start dealing with authorities or start dealing with international organizations or within the court setting, even if, let's say, privately they would be referring to themselves as survivors, they immediately switch to the term victim or victims. And one of the reasons is that that is the term that is like internationalized, and that, as Lea was saying, you know, quite pragmatically, if you like, strategically, that is the term that carries more weight in court proceedings. That is the term that carries a lot of emotions. That is a term that carries a lot of empathy, et cetera, et cetera. There's a huge debate right now here in the United States about some of the shootings that happened in Kenosha and whether those that were shot can even be called victims or not, et cetera, et cetera. You know, so because that gets you into wider debates of emotions, and you know, some judges don't want to have these emotions in the court, but obviously from the perspective of the survivors / victims, that's exactly what they want to be bringing into the courtroom. So I think this only just the discussion about which terms we use tells us quite a lot about how the public perception of these various crimes is or has been. I don't know if I've made myself clear, but I think it kind of adds and builds on some of the things that you were saying.
Yeah, but you know what's interesting? I was thinking while you were talking now, because you know most of those patterns in many ways were transmitted through our understanding of the Holocaust and Holocaust experience, and you know through different agencies and organizations, etc. But in Hebrew, actually, you don't say Holocaust victims; you say Holocaust survivors. So it's Nitzolei Shoah. So it is. But it is translated always as Holocaust victims. So it is interesting to see how this, there is something linguistically here that is being translated differently. And your point that, you know, you're so correct about, you know, you will not hear talking about post-communist crimes as survivors of that, because maybe you can say that the whole society is like in a status of survivors of something that was a regime, you know, a regime that imposed some kind of victimhood. But I think it's a great point. You know that I agree with you that, you know, this transmission from survivor, when it suits you, you know, you want to have this, again, power and agency, and then going back to victim because you want to get some empathy. So it's like different mechanisms to achieve different things in political discourses.
Can I just say one more thing? I also think that these terms and how they're being used a lot of the time, especially in the former Yugoslavia, those victims / survivors are being super manipulated. And I think it's just important to mention that because I don't want this to sound like, you know, they are being scheming actors or anything like that. They are being used and abused a lot of the times by the political parties, and these terms, victims and survivors, it also comes through the education that they have received through civil society and through those that have been supporting them. So they do have agency, and as Lea said, you know, I have argued quite a lot that they have quite a lot of agency, but it really depends. You would have some organizations that are super savvy in the former Yugoslavia with how they want to come across and, you know, how they build their narratives about their victimhood. And I think that is to the detriment of the rest of the survivors / victims, because they really, in a way, sometimes give them a very politicized bad name and reputation. So I just wanted to make that clear.
No, I think that is the main issue here. The main issue is actually that you know, even if you see different victim organizations, they see that they're competing over the same resources by the end of the day. So they have different deals with political elite and government, even just to be able to apply for different fundings. So they have all kinds of, okay, you give us an access to resources, in return you will get our voting electorate. So there are all kinds of trade-offs happening on a daily politics. And the fact that those who don't want to participate, those victims who feel like they don't want to be represented by organizations like that because they don't want to maintain this status of purified victims, are often again marginalized. You know, their voices are not being heard at all because they're not being represented through different organizations, etc. So we still have new forms of inequalities because we have those groups or pockets of people who don't want to play that game, or are not able to play that game, or are not in a position to be inside of that. So just when we start unpacking that, we see actually what are the real consequences on the ground.
So if I may, I will make rather a comment than a question to Leah and a question to James. The reason why I like your book so much is that you put in words questions which I had for 20 years, but well, actually it was not my main job to think about that, but still it's a real relief now. And it's about, it started for the Czech case, at least, with a book by Karel Bartošek, who was a Czech historian who is very representative of a certain generation of historians. He was a young fanatical Stalinist in the beginning of the end of the 40s and beginning of the 50s, was very engaged with the new communist regime, then became disillusioned, like most Czech intellectuals, engaged himself then in the Prague Spring to kind of repair the mistakes of Stalinism, then was more or less a dissident, then emigrated, and then came back in 1989, and in 1996, or 5, I don't remember exactly, he published a book to denounce the behavior of Arthur London, who had been another hot Stalinist, who had then been part of the Slansky trial and whose life was saved by miracle. And he emigrated to France in the 60s and wrote this famous book, The Confession, that became very important for the Prague Spring in 1968. And so Bartošek, who was really part of the Stalinist regime that did the worst excesses of communism, all of a sudden painted himself as a kind of a, first of all, both a victim, and we've already tainted spice, so to speak, of heroism that would really come to the fore in Czech public policy only 10 years later. So, but it was already there. It was really difficult to express at the time. And so he denounced London as being, a Stalinist, and at the same time he tried to hide that himself had been a Stalinist. So whoever reminded that he had been a Stalinist was, of course, only slandering, whereas the others were Stalinists and he was not. So, like all the processes you're describing were already there. So how, the attempt at censorship at the same time as the attempt as redefining one's identity as a victim that would soon afterwards become redefining of one's identity, not only as a victim, but as a hero. It was already there, all there in the beginning of the 90s. And I just couldn't, express why I'm so irritated by this, but I just felt something is completely wrong in the way he rewrites history, but it was really difficult to conceptualize. And I think what it raises, and I'm amazed that still in 2021, we have so little epistemology of what a victim is. And of course, he used another trick that you described very well, is to use numbers and very rapidly, like the year after his book came out, the Black Book of Communism, where the biggest power of the Black Book of Communism was to yield enormous numbers, 100 million victims of communism, which is 4 times more than the 25 million victims of Nazism. And no one asked actually, what is a victim? And Bartošek had the chapter about Czechoslovakia and actually the chapter about Central Europe outside of Poland in this Black Book of Communism. And he wielded the figure of 200,000 victims of communism in Czechoslovakia, but without ever defining what is a victim. And to this day, we don't really know what he meant. Like, what is a victim? Is it somebody who was executed? Is it somebody who was sent to jail? Is it somebody who received a fine? Is it somebody who lost a job? Is it somebody whose children were forbidden from studying? We don't know. There is no epistemology of victimhood in the Czech Republic until today. And I think in most of the post-communist countries. And I think where there was maybe an excuse, so to speak, in the 90s, it was really necessary to rebuild the country, and probably people had better things to do. Like now we're more than 30 years later, and it's more than high time, I think, to start doing that. Which brings me to my question to James, that raises basically a very similar question, is that the epistemology of an archival document. What is an archival document, and what does it tell us? How was it produced, by whom, and for what purpose? We are, like, again, in the Czech Republic, we have the fetishism of the archival documents. Like, if we manage to put at the disposal of the public all the archival documents, then everything will be fine, and you know, all the problems with the past will be settled. And no one ever asks, actually, what will you find in this archival document, and how are you going to read it? What is it going to tell you, and how will you be able to understand what is in it? And that is a question nobody ever asks. Like, we are actually in the process of digitizing millions of pages of archival documents, and no one ever asks, how are we actually going to read it? And can we read an archival document coming from the secret police archives just like that? Like, don't we need any keys of understanding? No, like, the question is not asked. Now, my question to you is, how would you summarize in 1 or 2 sentences the difference of approach between Romania and Moldavia, considering the historical circumstances, to the opening of the archives, or to the opening, or to the reading of the archival documents? I don't know, Leah, if you want to react first or not, and then James.
No, I think you're completely correct about, we all talk about victims, we all talk about victimhood, but actually we think of different things when we talk about victimhood, but and yet again, there's so many techniques and mechanisms how to become a victim now. But if you want to see definition, it is interesting to take a look at the documents issued by United Nations in the 80s and the 90s, how they define victims. So the main point is something that is being done to them. You know, those, so again, it is very passive in a way that you're a victim because some injustice was done to you. So again, we can see how from there, this is first of all very static, and it takes out any agency, takes out any messiness, because you can, you know, and we don't talk about it a lot or enough, that you can be at the same time victim and a perpetrator. You can be at once, you know, you can be a victim in one situation, but then again, perpetrator in different situation, or it can, because life is not static, especially not if we talk about situations that are extraordinary, such as war, genocide, you know, post-communist crisis, where you're put in a situation that you need to make decisions that are based on many different interests, not only your best interest. So again, we know we don't talk enough about it. And I will just finish my comment with one small a comment from a different conference where I was having a keynote speak about Jasenovac and something like that. And I said enthusiastically, which is, you know, Jasenovac was a huge place of extinction of Serbs and Jews in Croatia. And they said, you need to change your concept, the way you think about museums. Let's try to think of museums as escape rooms. You get into a museum, you have a dilemma. You need to actually understand, what are you going to do in this and this situation? Are you going left or right? Are you going to sell your neighbor and go through this door, and then you will have another situation? If you want to teach something, you need to teach people to understand what does it mean to be, what is this messiness? How you deal with that in a real life? What would you do in that situation? And not just to try, oh, it's easy now to say, oh, they were victims, you know, so you have empathy, or you say, I would not do it that way, but you don't have, you know, the messiness of the situation. So yeah, they were appalled by my suggestion. Okay.
The Czech historians are actually specialized in writing kind of video games where you're faced with this kind of choices. There are already 2 or 3 done by historians of the Academy of Sciences, and that's really interesting. James?
Great, thanks. That's a great question. Well, the kind of the preamble you gave to the question is really, really interesting. I mean, it's how to read a file, and how do we know how files should be read, or how files will be read. And I think, you know, of course, there's no consensus over that. What's interesting is, you know, how do ordinary people perceive those files, and how do they perceive the way that they are being read by historians or by political commentators or by journalists and so on. We did you know, field work with communities that have had access to their own files and have processed that. And we've approached communities with their file and said, would you like to gain access to your file, you know, and kind of try to gauge their responses and include those in our research. So what's interesting is, you know, people are afraid of the file for what it might contain because of this kind of in Romania, this kind of pervasive surveillance and intrusive system. But they also, the people that we spoke to, recognize that they wouldn't be able to read it themselves. They do recognize that they wouldn't be able to just pick it up and read it. And so one of the communities very, very, very tellingly said, yes, we'd like access, but we would like one of your team to come and sit down with us and tell us how we're supposed to read the file. So I think there is an understanding that, you know, you can't read it sort of directly. But then, you know, you come to the question of how have historians read files. And there is a great reluctance in Romanian scholarship, especially, amongst many historians, to explore other readings of the archive than a kind of social constructionist one that is focused on in understanding the institution and the system of repression that the archive is an expression of. So not trying to read the archive against the grain or along the grain, along the archival grain, to uncover voices, lost voices and marginalized communities and so on, which was the approach that we took. That's relatively new, trying to, you know, use sort of archival methodologies that have been devised in kind of post-colonial context in the Secret Police archive and using them in a way that tells us something more than about the actual repression itself. But you asked me to give a sort of a kind of summary for like the difference. I'd say the key thing is that because in Romania you have 25 years of leaked files and access to files by ordinary citizens, you have these processes of kind of you know, journalists and vigilante actions through secret police archives. You have this focus on revealing truths and secret agents through files. That has really shaped the public perception of the file. And I'd say now we're going to a phase of boredom amongst the sort of mass populace in relation to those kind of revelations. But they really shaped, if you like, what was expected of the files, that revelations, you know, the revelation is what's important. It's not what happened or what we knew to have happened because of some abstract historical past, but really the kind of the ongoing process of revelation. Whereas in the Republic of Moldova, you just don't have that. The files have been closed. There have been discussions around opening them, you know, for lustration purposes and so on, and for criminal prosecution. But the investment of ordinary people in trying to gain access to their own files and understand their own past in relation to their experience of late communism is just not there. And the possibility is not there because most of those files anyway are not in the Republic of Moldova. So instead, I'd say, you know, in relation to the archives, it's much more historian driven than it would have been, than it is in Romania, because the democratization of opening the archives to ordinary publics had all of these other consequences that perhaps were not intended. The idea was to empower victims, you know, and you know, that discussion there about, you know, just who constitutes a victim. In late communism in Romania, you know, the victim was anybody that had a file. if you have a file, then you're either a victim or a perpetrator. If you're a recruiter's an informer, you're a perpetrator. If you have a file, even if it just meant that somebody reported on you, you were a victim, you know. And that process, like in other contexts, kind of washed over the difference, if you like, between, or the grey areas between victim and perpetrator, trying to create clear water between different categories of people that can be unearthed in the archive. Whereas that's not really a process that's observable in the Republic of Moldova. In Republic of Moldova, as I said, you know, which has this peculiar relationship with Romania anyway. So, you know, Romanian historians and Moldovan historians speak to one another. They understand each other's context and write about, you know, those two contexts. But in Moldova, you know, public opinion is very much, and this is observable if you look at the kind of political relative power of two kind of political blocs in Moldova between pro-Soviet and pro-European, is that the late Soviet experience, which was not particularly a negative one in Moldova. You know, people have nostalgic memories for the Soviet period. People my age, a lot of people that I know my age and slightly older, lament the end of the Soviet Union and Moldovan independence, precisely because of the trauma that came with independence. So there's no real appetite for placing a heavy burden of crime onto the Soviet regime on the territory of the Republic of Moldova. You know, from the other side, from the Soviet side, there is, or the pro-Soviet side, there is more of an appetite for uncovering the crimes of the Antonescu regime, the entanglement of Romania in the Holocaust, persecution of Roma, and so on, as a way of deflecting, if you like, away from the mass deportations of the 40s and the famine and so on. I don't know if that's answered your question.
Yeah, you have. Thank you so much. I just realized it's actually real late. I was like so taken by debates that I didn't watch the time. But does anybody else have a question or want to raise something, some point? Then if not, I will close this session and invite you to come back tomorrow at 10:30 Central European time. The waiting room will be open already at 10:15. And I'm sure we'll have another great session. I think today was really great. Before we leave, I have one question. Does anybody have an email for Zoltan Dujizin or Dujizin, I don't know how to pronounce his name, by any chance? Because he's not answering to my mails anymore. And I think his Colombia address just doesn't work anymore. No? Okay, so I'll try to figure it out until tomorrow. So thank you so much for participating this morning and see you tomorrow. Bye.
Thank you very much. Bye-bye.
Bye.